Mayor directed my client to appear, was proceeding to abuse my client. Quite honestly, the mayor instigated the incident. Cases that it is politically motivated. This can't happen. This isn't how we govern in this country.
I want to make sure the whole city is there.
This lady, Carla Oliver, had charges of breach of peace brought against her for a skirmish in the Highland Park, Michigan City Hall. She found out the hard way that you can't fight City Hall, although her idea of fighting City Hall allegedly meant assaulting the mayor. She claims the mayor is the one who started it, but after a 5-month investigation, the prosecutor disagreed and filed charges. Ms. Oliver is well represented by her attorney, but I could tell throughout the entire hearing that she was poised to turn into a Karen. She Karened a little bit, but now I'm excited for a future trial. Carla plans to pack the courtroom with like-minded Karens. Let's roll, nerds.
Okay. And so we are on the record in the matter of Highland Park case number, the 30th District Court number 25536. City of Highland Park versus Carla Oliver. And appearance for the people, please.
For City of Highland Park, Tail Manager will present P810003. I didn't know.
May we all first judge my client?
Yes, that's right there. Yeah.
Thank
Okay. All right. I'm sorry. Council, your appearance again, please.
Tail Manager will present P810003 on behalf of the City of Highland Park.
Thank you.
May it please the Honorable Court, Gilbert Borman, P37642.
All right. Thank you. And your name, please.
Carla Oliver.
Okay. Just make sure your hands are on your office, please. And it's today's the date scheduled for the motion hearing. And counsel, Mr. Borman, you filed the motion to dismiss, correct?
Did.
All right. And the people filed the response.
They did?
All right. And are we proceeding with the motion hearing?
Yes, if you please, Judge.
Okay. And so counsel, you may proceed.
Judge, now is the date and time set by the Honorable Court for this hearing. And it's our contention that our brief is very clear. Just going to hit a couple of high points on it in terms of what it has to say. First off, if my client had really committed a breach of the peace on that day, the chief of police of Highland Park was right there. She wasn't arrested. Secondly, and there's a problem with evidence on this in that we do not have any video from the hallway where everything took place. To refresh the court's memory, the actual confrontation between my client and the mayor started, my client was standing in the hallway, the mayor was in a room and immediately at the end of that hallway, and the mayor had directed my client to appear and was proceeding to abuse my client, knowing that she was in the hallway, knowing that she could hear her all so clearly. And on at least 5, probably 8 or 9 occasions, said, she's suspended, no pay, she's suspended, no pay. She kept saying it, knowing that my client was there. Quite honestly, the mayor instigated the incident, and this can be shown. Secondly, and probably just as importantly, the incident happened on December 20th, 2024, but the case wasn't even filed until April 2023. The court should ask, why did it take so long? And that gets to our main concern with this particular case, is that it is politically motivated. That this was done at the behest of the judge, by the leader of the city, because she wasn't happy with my client. And I would also add that my client had made a number of comments about city government in the couple of weeks preceding the handing down of the case. And there can be no question that this case it should never have begun. And the city knew or should have known better, and they filed it, and here we are. And it's not fair to my client, obviously, to be facing charges. And on top of that, they accused her of a battery. Yet even by any of their own discovery, they admit that there was no physical conduct. So why was she charged with battery too? Again, it goes to the political motivation to harass and intimidate somebody, questioned how the mayor was leading the city, which gets us to where we are today. A judge sitting in a hearing, completely independent of what the events, and we're presenting you a picture that should cry out to the court saying, this can't happen. This isn't how we govern in this country. And I think that's pretty much, think that pretty much is it. There was no breach of peace. If there was a breach of peace, it was instigated by the mayor. She absolutely knew my client was in her voice shop. She demanded that my client be there. And so she was harassing and intimidating my client. And finally, when my client couldn't stand it anymore, she walked into the room and said, back off, and then immediately backed off. Well, then the mayor became the aggressor, and she took steps towards my client. And my client was the one who was forced to step back. Judge, if you have any questions, we're happy to answer them. Thank you.
Okay, so I do have a quick question. And so I just wanted some clarification. Because I thought you stated that it was at the behest of the judge.
I'm sorry, not at the mayor, not the
Okay, the
judge.
mayor, okay.
If I said the judge, that was a incorrect.
Okay. You also said it was filed in 2023, so the
I'm sorry, it was April 23rd, 2025.
Okay, all right. And then the offense occurred April of 24.
It's December of
I mean,
2024.
December 24. And so, counsel, your position is that there's not even a triable issue of fact.
That there can't be any question of it. And if it ever came to it, the court would inescapably reach the conclusion that the mayor was the aggressor and provoked the incident.
Okay, thank you very much. And Madam Prosecutor, I'll hear from you next. And response.
Thank you, Judge.
Thank you.
Good morning, Your Honor.
Good morning.
At the outset of the case, defense counsel's exact argument is why this case needs to go to trial. Everything he stated is an issue of fact. He states that one person started over the next person, or who was the aggressor or not the aggressor. Those are the exact issues that needs to go to trial to be decided. To his argument of this case, there was no battery. We all know, going to law school, you learn that assault and or assault battery comes together in the Michigan statute. The statute says that it's either an assault or an assault and battery. There does not have to be a battery to have an assault. We know that. That's clear by case law. That's clear by the statute that an assault can occur without a physical touching. So the whole argument of there was no battery, so this case can't be a real case, doesn't matter because an assault did occur. And if he's stating that an assault did not occur, again, that is an issue that needs to go to the trier of fact to determine whether an assault actually occurred or not. If this argument that defense counsel was making was a valid argument, everyone would get off on crimes. You could just file a motion to dismiss and say, hey, this is not valid. It should not go to trial. Trial is the reason for this to determine if Ms. Oliver is guilty of this or not. Now, his arguments about political retaliation and all of that, that has nothing to do with the charge of assault and battery, which is what we are here today in court for. That's all. I stand on my response for everything else.
Okay, thank you, counsel. One question I have is regarding this incident occurring December 20th and charges weren't brought until April of 25. Can you speak to that, please?
So I don't know what took so long. I know once it hit my desk, I reviewed it and it was signed immediately. The police department had to think their own way. I don't know if they were doing an investigation. They maybe had to get some witness statements. I can't speak to what happened before the actual warrant hit my desk and it was signed off on. But we all know sometimes cases do take a while to be filed. The police has to do their job. They have to investigate, speak to people, do whatever they have to do before it gets to the prosecutor to be signed off on. But I do know there was no delay between once the warrant hit my desk and the sign.
Oh, I'm not suggesting that. I was just wondering, the point of my question was to determine whether or not there was the delay between December and April because of investigation or witness statements, just as you've indicated. I was just wanting to know why the delay.
That would obviously be my assumption that maybe they were trying to investigate or get statements beforehand.
Right. So this show of the date of the warrant request was Thursday, March 20th of 2025. And then when was the date that the warrant was authorized?
I don't know the exact date. I don't have it offhand. All of mine are in the office, of course, but it may have been the April date. Let me double check. I remember getting that email from the detective. Didn't know what did you know what about a copy? I don't have that information in front of me, Your Honor. I'm sorry.
Okay. The court will note that there is an investigative summary dated February 7th, 25, which would further support Madam Prosecutor's statement that there was likely an investigation that was going on. There were statements further gathered on February 14th of 2025.
What was the April date that she just stated, Your Honor?
April 23rd. So I will say that it does look like it was authorized by Madam Prosecutor April 23rd, and then sworn to by Judge Officer Holly on April 23rd as well. All right, so counsel, so Mr. Borman, I don't find there's a reasonable delay in the filing of the complaint warrant.
Judge, if I may,
Okay,
might rebut just one thing, but I think it's very, I really want to stress this point. Judge, the chief of police of Highland Park was present at the incident.
Yeah.
If he felt he was not,
ma'am, I can't show.
I'm sorry, I thought he was.
Well, this just shows why why it would have to be, there's a question of fact. There's a question of credibility, all of which this court is not to decide at this point. There were charges that were filed, and the issues that you raised, counsel, are questions of fact, questions of credibility of witnesses, all of which is to be done by the trier of fact, which I believe there was already a request for a jury trial. There was some statement there was going to be a jury trial.
True, but Judge, this took place in the City Hall of Highland Park, which is also, I believe the police are in that office as well. If there had been a real breach of the peace, the police would have been summoned immediately. Immediately. That's what didn't happen. And I think that speaks to the lack of fear on behalf of the complaining witness, the mayor. And I don't think they can overcome that. They'll never overcome that.
Well, counsel, it sounds like that's the start of your opening and closing arguments for trial. However, that is not something that this court is to make a ruling on at this point. It's a factual issue. It's an issue for the trier of fact. There's not a legal issue that is before this court. So, as such, the court has to deny the motion to dismiss, and we'll set this for trial.
Very good. Thank you, Judge.
So that's going to look like a disaster for doctors anyway, because I didn't go there, so I need to confirm with circuit district boys. They have a bill. So let's okay. Ms. Wilkerson, are there certain days that are your Highland Park prosecution days?
Our criminal misdemeanor docket is Wednesdays, but if we have a jury trial from that docket, is normally set on a Thursday. We don't do the jury trials on Wednesdays because we have a regular docket, so it'll be set on a Thursday.
Well, I'm going to see if it can be set on a Tuesday because I have my state docket on Thursday. Can you do Tuesdays?
I don't think it's necessarily me. I don't know. We have a different docket on Tuesday. So,
I understand.
but here's the thing though. It should not matter, Your Honor, if you are presiding over the case because, we should be able to do Tuesdays. Yeah, because the building that we operate out of would not be the building that the jury trial would be held in. So we could have the jury trial at that other building.
Where's the jury trial held?
At the City Hall building, but we don't operate out of that building. We have a different building where we hold court from. Well, where we are stationed.
Probably stay. Well, there's gonna be a lot of logistics to determine.
Yes.
Maybe, yes. Yes.
Okay,
But I'm sure if you choose a Tuesday, they should be able to make that work, I think. I don't know.
did Tuesdays work for you, council?
It depends on Tuesday, but I would assume we'd be talking about some date out in either late September, early October.
Absolutely, because my September dockets are absolutely full. So
Okay.
we're talking, early October, but.
I would actually prefer mid-October if you don't mind, Judge, just because I've got a couple of things that I know is in early October, and I'd rather have this just fall after that.
Well, if it works that way, then possibly, so I'm looking at October 14th. Does that work for both of you?
I mean, 1 second, it should be fine.
Hopefully right home, it looks clear for me.
We typically do jury selection the afternoon prior day, but we'll just pick and go that day and do it right at 8:30.
That date will work, Judge.
Will work.
Will work.
Okay. So, and just so you're all aware, since we're just doing it in one day, if it goes past typical, traditional court hours, we're just gonna stick through and continue on. Typically that's when the jurors prefer anyway, so they don't have to come back another day, but that way we can just, don't have to worry about cleaning up another day or otherwise. Okay, so I'm going to have all of you have a seat out in the lobby for a few moments. I'm going to have my court administrator reach out to the 30th District Court to confirm that that date works for them. And City Hall also.
I really, really need to get out of here. I did not know this was gonna take this long, and I'm like 40 minutes away from my next destination. I have to be there at 1:30.
Okay.
Just do it by mail, Judge? That's
Well, we have your email, correct?
Yeah.
Yes. Okay, so for right now, we're just gonna stick with October 14th. If there's an issue, then we will communicate with everybody. But I will also indicate this, that witness and exhibit lists are due by September 19th, and criminal and proposed jury instructions. And then we will do a final conference. That way, what I do is be confirmed to see if there's any issues with any witnesses, any of the exhibits, any of the proposed jury instructions, and then we have all that finalized so that on the day of trial, we don't have to utilize any of that time and we just go. Okay, so we will do the final conference on September 23rd. At 11 a.m.
That may not be a good date for me, Judge. Just hang on 1 second, please.
That day wouldn't be good for me unless we do it like later in the morning.
If the 23rd doesn't work, I'm out the 22nd.
Hold on, hold on, counsel, she was still speaking.
It's fine. I was just saying it doesn't work.
You said later morning?
Like if you push it later in the morning, 10:30, 11 maybe, but
Okay,
before then I can't.
okay, and
Could we do the 25th?
we can do the 25th.
That would work for me. The rest of the week is just, I've got conflicts.
The 25th work for you, counsel?
It would be the morning of 25th.
We could do 1 o'clock, we could do it in the afternoon.
That would work better.
Okay, let's do that. Let's do the 20. Does that work for us, Ally?
Yes. And it's for
Final conference, I call it. So your client doesn't have to be present, counsel, unless there's a resolution that's going down the record. Your client doesn't have to be present.
I have a question. Mr.
You
Montgomery,
should stand up when you're addressing.
sorry, I've never been to court before like this. In regards to the bond that I have, right? Read the letter and it says no contact, which I haven't contacted her. I don't need to contact her. I just want to make sure because I am very vocal on our Highland Park social media. I want to make this clear about this court and this situation that's happened on that page. I want to make sure the whole city is there
Posted that where?
in court that day. So I want to make sure that it's not considered intimidation at all. That's what I'm asking. I want to be able to vocally state about what's going on.
Let me state this. Let me say that the courtroom is open to everyone.
Okay.
Okay, and I also operate a courtroom that is going to maintain decorum and respect.
Mm-hmm.
Just keep your hands
I'm
up.
sorry. I'm sorry.
So if any of that is being violated,
Mhm.
that will be dealt with on that day.
Mhm.
There has not been a motion to close the courtroom. There's not been a motion to exclude anybody. So as your attorney will indicate, the courtroom is open to the public. That's where we stand right now.
So I can post.
You still have your first movement, right?
Okay. That's it. That's
As
all.
long as you're not violating bond conditions,
Yep. I just wanted to be clear what intimidation actually meant as far as that's it.
Telling you what your case is allowed. That's not.
Oh, okay.
Okay.
That's what I want to be sure of. That's all.
okay, did your attorney clarify that? for you?
Sorry. Yes, Your Honor.
Okay,
Thank you, Judge.
all right. Anything else?
Nothing further, Your Honor.
Okay, bond and conditions are continued and we will go off the record.